to proceed, and the parties have rested. Anything else to bring up for this punishment phase, state or
Nothing
defense?
further from the state, Judge.
Nothing further on.
The evidence is before you, ladies and gentlemen, in both you can consider not only the evidence presented in the guilt or innocence phase, but also in the punishment phase in making your decision. And at this time, I'm going to read to you the jury charge, which contains all the law necessary for your deliberations on this punishment phase of the trial. And again, in continuing to discharge your responsibilities as jurors, you must continue to observe all the instructions previously given to you. As before, the original will be left with you to refer to as necessary during your deliberations.
The judge calmly explains the serious consequences the defendant now faces. Under Texas law, the crime carries a prison sentence of 2 to 10 years, along with a possible fine. At this moment, the entire courtroom understands that the jury's next decision will determine his future.
Punishment. An individual adjudged guilty of a felony of the third degree shall be punished by confinement in the institutional division of the Texas Department of Criminal Justice, in other words, prison, for any term of not more than 10 years or less than 2 years. In addition to imprisonment, an individual adjudged guilty of a felony of the third degree may be punished by a fine not to exceed $10,000. Instructions on probation. The defendant has filed an application for probation. Probation means the release of a convicted defendant under conditions imposed by a court for a specified period during which the imposition of sentence is suspended. Our law provides that after punishment is assessed, the jury may recommend probation of that punishment if, one, the prison term assessed does not exceed 10 years confinement in prison, and in this case, you cannot exceed 10 years based upon the statute. That's the maximum length of time a third degree felon can be sentenced to prison. And two, the jury finds that the defendant has never before been convicted of a felony in this or any other state and recommends probation. Our law provides further that if a jury recommends probation, it must be granted by the court. Your first responsibility is to assess what you believe is a proper punishment for the defendant in this case. From up to 10, no less than 2 nor more than 10 years imprisonment, and also a fine of up to $10,000 can also be added to that. Then if and only if the prison term you assess does not exceed 10 years confinement, you may consider granting the defendant probation of that punishment, should you find the defendant is legally qualified to be considered for probation. If you grant probation, you place upon this court the responsibility to supervise the defendant. In discharging this responsibility, the court may impose any reasonable terms and conditions of probation designed to protect and restore the community, protect or restore the victim, or punish, rehabilitate, or reform the defendant. You are allowed to assess a punishment of 10 years or less and not recommend probation. You are further allowed to grant the defendant probation of a penitentiary term, a fine if one is assessed, or both. If you grant the defendant probation and the court subsequently finds that the defendant has violated one or more conditions imposed on probation, the court can either continue, modify, or revoke the defendant's probation. Extraneous transactions or bad acts. You are instructed that there may be evidence before you in this case regarding the defendant having committed or participated in crimes other than the offense alleged against him in this indictment that you have found him guilty of in this case. Such other evidence can be considered by the jury only for the purposes of judging the standby. Only for judging the credibility of the defendant as a witness. And in this case, the defendant did not take the witness stand, so that does not apply. You can also consider such other actions extraneous transaction or bad acts or crimes, if any, if first you find and believe beyond a reasonable doubt that the defendant committed or participated in such crimes, and you can apply that information toward your consideration of the punishment assessed in this case. And if you do not so believe or have a reasonable doubt that the defendant did or did not commit such bad acts or transactions or crimes, you cannot consider such evidence for any purpose. Does everybody understand? Defendant's election not to testify. Our law provides that the defendant may testify in his own behalf if he elects to do so. And this is a right given to a defendant. And in the event he elects not to testify, that fact cannot be taken as a circumstance against him. And in this case, the defendant is elected not to testify, and you are instructed that you cannot and must not refer to or allude to that fact throughout your deliberations, nor take it into consideration for any purpose whatsoever. General instructions. The attached verdict forms are supplied for your use. When you have reached your verdict, your foreperson should fill in the appropriate form and sign their name as foreperson. In arriving at your verdict, it is not proper to fix the punishment you assess by any system of averaging. Your verdict must be determined only by a full, fair, and free exercise of the opinions of each juror based upon the evidence presented. Your verdict must be unanimous. Your failure to follow the law contained in this charge could result in a mistrial being declared, and your deliberate violation of these instructions could result in your being held in contempt of court. All right, we have several options available, ladies and gentlemen. First option, we, the jury, find the defendant has not before been convicted of any previous felony offenses as alleged in the indictment and assess his punishment at confinement in the institutional division of the Texas Department of Criminal Justice. I'll call that prison, for a term of blank years. If you find that's the proper verdict form, you place no less than 2 nor more than 10 years in that, and a place for the foreperson to sign. The other option, we, the jury, find that the defendant has not been convicted of any previous felony offenses as alleged in the indictment and assess his punishment, confinement in prison for blank years, and that would be no less than 2 no more than 10. In addition to such imprisonment, we assess a fine of blank dollars not to exceed 10,000. Place for the foreperson to sign. Next option, we, the jury, assess the defendant's punishment at confinement in prison for a term of years, no less than 2, no more than 10. We further find the defendant has never before been convicted of a felony in this or any other state and recommend that this punishment be probated. A place for the foreperson to sign. Next option, we, the jury, assess the defendant's punishment at confinement in prison for a term of no less than 2, no more than 10 years. We further find the defendant has never before been convicted of a felony in this or any other state and recommend that his punishment be probated. We further assess a fine of blank dollars. So here, the defendant is placed on probation from confinement, but a fine up to $10,000 is assessed, a place for the foreperson to sign. And your final option, under the law, we, the jury, assess the defendant's punishment at confinement in prison for blank years, no less than 2, no more than 10. We further assess a fine of blank dollars up to $10,000. And we further find that the defendant has never before been convicted of a felony in this or any other state and recommend that this punishment be probated. So in this case, he's assessed a term of confinement, a fine. Both of those are probated and suspended and under the probation of the court. A place for the foreperson to sign. Only one verdict form can be signed. Does the jury understand your different options under law? Okay. The state may open and close final arguments. What says the state? You may. Thank you. Go ahead.
Good morning, ladies and gentlemen. What we have here is an individual has a history and troubles going back in his kid. You heard about his juvenile record. He has possession of controlled substance false conviction, file charge, and an unlawful carrying weapon charge. And then you can see, and I'm not gonna shy away from it, we're gonna. That picture on his live stream. You saw him out there on the scene of this incident that you are a crime that y'all heard, a lot of guns in the car, a lot of issues here. And at 20, he's still a kid. All right. And I say that because you've seen how he behaved. Some of us at 16, 17, 18, we're pretty mature and grown. You know, some of us leave home at 18, I did go off to college and handle ourselves and live a good life. Some at 20 are still living at home, still immature, not grown up yet. That's what we have. You know, he's 20. He's a kid. You saw his behavior, his actions, what he was doing out there, laughing, goofing off, and not taking it serious. Being hauled into the police station for a shooting, and you saw how he would react when he got out down the hall. And then even when he was let go, how he was actually in the parking lot. You saw him the last couple of days here in court too. I'm sure you saw some stuff. Kind of getting and laughing about things. You know, he's here on trial for something very serious. You could put him in prison. Okay. So what do we do with something like that? Well, you have two choices. You just heard the judge read out the choices. Read out 5 different kind of options there, but there's really coming down to 2 choices. Then it goes whether the fine goes with the fine, prison or probation. Okay, and I told you that in my opening earlier. What do we do? Prison or probation? Let's talk about each one. Well, first of all, back up probation. First of all, he is eligible. Okay, sometimes we have to establish that first, that there's no prior felony convictions. Here, there are none. The state didn't allege any. There's no evidence of that. The second thing is it has to be a punishment of 10 years or less. In this case, like you said, that's a maximum, so it qualifies. Sometimes we're dealing with cases where the punishment range is 2 to 20 or 5 to life. We have to argue to the jury to first of all sentence him to 10 years or less, and then go for probation. Here, it's all there for you, okay? You don't have to make that decision. You just have to make a hard decision of whether that's the right thing to do or not. Okay. Let's talk about 2 options. Okay. Prison. You give him prison, he'll do up to 10 years, whatever you determine. Right? He'll be living and interacting with criminals. Other bad life, bad everything around him. And probably less than 10 years, he'll be out because we know the prison system does. Then he'll be back in our community. No better off than he was before. No guidance, no change, no anything. Just living with other criminals, talking with other criminals. I don't think that's the best choice. Okay. What he did was bad. I'm not going to demean that or say it's not bad. Somebody could be killed, right? Very dangerous. But doing prison, what does that accomplish? Takes them off the street for up to 10 years. Yeah. Okay. But the second option, let's talk about that. Probation. Okay. First of all, there are a lot of people talking, especially in my business, about probation is just a way out. It's not really punishment. It's still punishment. You still have all the restrictions, all the fines you have to pay, the community service you have to do, all the restrictions that goes with it, all the even if you don't assess them a fine, all the fees and costs that go with it. There's still other fees and costs that are not part of the fine. Drug testing, any other restriction the judge can place on them. The judge is over that, and he's the one that decides what restrictions, what classes, whatever it may be on it. It's still punishment, okay? But on probation, you have oversight, you have guidance, you have to check in, you have to live right. Something that we take for granted because we all, I'm sure, live right, okay? But people need that extra oversight. Help mature in the right environment, okay? Because over the next up to 10 years, he's going to mature one way or the other. Depends on who he's with and who's helping him mature. Being on probation, checking in, doing all you're supposed to do, or the criminals he'd be living with. It's tough call. But if he's on probation, 1 or 2 things are going to happen. Number one, he's going to do what he needs to do. Finish probation, learn to live the right way. And then we as a society are all better off. He's better off, we're better off, the community's better off. We have another productive member society. Or two, he's gonna step out of line. And screw it up. They're gonna be here watching him and he's gonna be watching him and then back here to court. Like the judge said earlier, revoke his probation, put him in prison, modify it, do sanctions, whatever needs to be done. That's up to the judge over here to do what he needs to do. So when looking at the options here, probation seems the only option that really makes sense, right? It's the only that puts everybody in a better situation. Not only my clients, get them on the right path, society. We don't have someone getting out of prison in however long it's going to be to get out, right back in the streets, right back to the guns, right back to the lifestyle. We have probation and keeping them away from guns, keeping away from the bad people, keeping him on the right path. And so that's why I think that's just the best thing in a case like this with somebody like Kim that we need to do. Thank you.
State of Texas.
You can't help somebody that doesn't want to help themselves. Mama got up here, she said she's tried. I believe she's tried. He doesn't want to change. She said that she sent him to daddy. Daddy probably tried. He doesn't want to change. He got that case in April of 2022. Got on probation. With that looming over his head, after April of 2022, the unlawful carrying and the possession case, September of 2022, he gets another unlawful carrying case. He doesn't want to change. They sent him to placement through probation with the juvenile department. He gets out. That was supposed to help him change. But guess what he did when he got out? We're here because of all the evidence you heard yesterday and the day before that, because he's still packing guns and being reckless with guns. So the case we're here about happened June of 2024. So when somebody's charged on that and they're waiting for their trial, they can get out on bond and continue out in the community. They're the case looming over your head where you're facing 2 to 10 years. You think you would get it right and change then. But you heard from our witnesses today. He still doesn't want to change. They fired 27 rounds from 3 different weapons. One of them they said was the long kind of gun outside of those people's house. Those people don't even know who it was. And his immature, his childishness, it helps him to get caught. It doesn't buy him a chance to get on probation. But just like with the first case that we're here for, when he got out the car, he left the gun sitting right there in the seat. He goes back to the scene because he drops his phone. His phone with his picture on the front of it, his phone with his ID on it. Not only does he leave the phone and the ID there, he goes back to look for them. And then he gets caught. Not because he wanted to change his life and do the right thing. He's addicted to guns. And that's not even the problem. What he does when he gets his hands on those guns, that's the problem. Ladies and gentlemen, Deontay needs a break from us. He needs a break from our community. He needs to go and figure out, how can I become a productive citizen and stop being a destructive citizen? Defense counsel talked about him going to prison and he'll live with the other criminals. And he'll talk with them and they'll talk about crimes. And that's fine, because guess what? We'll be safe. And that's who I'm concerned about. So not only does Deontay need a break from the community, we need a break from Deontay. He's headed down a bad path. He's been headed down a bad path for some years now. Nobody's been able to get him on track. not probation, not mom, not dad, not even the fear of this case over his head got him on the right track. He goes out and does it again. So do we really want to put him on probation to where, yes, he has to check in with probation officers once a month? They don't live with him. They don't follow him day to day. They can say, hey, don't have a gun all day if they want to. Is that really going to stop him from going pick up another gun? No, that's his thing.
Mhm.
Defense counsel said something about if he messes up his probation that we're watching. Yeah, I'm watching from my desk upstairs. I don't know what he's doing out there. But if he screws it up, then he can come back and face prison. But at what cost is he going to screw it up? I want you to look at the trajectory that he's going at. It was 3 people in that last house. That guy had just gone to start his car to go to work, and but for God, he went back in the house. Any of those people at that house on Euclid could have been shot up or killed that day. Deontay doesn't care. I agree he needs to grow up, but he needs to grow up sitting down somewhere where somebody has some real control over him. Probation, they're watching from their office. They say, hey, come in here, come do a meeting for 30 minutes, come in here and do a drug test. And they're just going to ask him, hey, have you been around guns? He's going to say no. Have you been around bad people? He's going to say no. But we already know what he's doing. So before this trajectory continues, it's already escalating. So before it gets way up there, he needs to go sit down. Not at home with mama, not at home with daddy, not at the probation department every month looking at them. He needs to go to prison. This is our community. So now it's on you to think about how long is it going to take for him to grow up. That's the number you got to put on that paper. I don't care about the fine. I don't even know where the fine goes to. I care about our community and trying to keep some folks safe. So when you go back there, I ask that you overlook that probation paper. Just like he would laugh at it. It's a joke. Just like he has thought all of this has been a joke since day one. When you look at that probation paper, think of it the same way. It's a joke. And actually put a number down that's going to keep our community safe. That's going to keep those bullet holes and those guns out of his hand for many years. Thank you.
Right, ladies and gentlemen of the jury, at this time, let me make just sure that all. This time I'm tendering the jury charge for the punishment phase to the bailiff. I'm going to ask you to please step down from the jury box, follow the bailiff into the deliberation room. We will await your verdict on this second or punishment phase of this trial. Thank you. And as well, alternates, thank you very much for hanging in there with us and holding vigil. If you'd be so kind to wait outside.
After hearing all the testimony and final arguments, the judge gives the jury their final instructions. The courtroom waits in silence as the jurors leave to deliberate. Now, the decision is entirely in their hand, whether the defendant walks out on probation or goes to prison.
We will recess, awaiting a verdict. Thank you.